Hi everyone, this is Danielle O'Gorman, and I am here with a lecture for you about the U.S. courts and a little bit about how to debate them. A lot of this is going to be defining terms and explaining concepts so that when you have these courts debates, you're more comfortable with them than you might otherwise be or that you might be now. So this is a great lecture if you don't know much about the court system and if you're interested in learning more about it. So when we talk about courts, we're talking about kind of a lot of different types of courts. And so one of the big divisions between courts is the state court system and the federal court system. And these sort of run parallel to each other so that they perform similar functions, but with different operational or governing rationales. And we'll talk a little bit about what kind of cases get prosecuted in state courts versus federal courts in a little bit. But know that just like every other sort of type of court or type of government is divided in the United States at the state level and then at the national government, sort of federal level, so are the court systems. And then we also have both criminal and civil courts. And so that is another sort of defining characteristics of our court system. We don't really need to talk that much about civil courts for your purposes. Most of these affirmatives will deal with the criminal justice system. So, but know that there is a sort of division between criminal courts and civil courts. So I guess a good place to start would be at the Constitution, which is the founding document of our country. The part of the Constitution that governs the setup of the courts is Article 3. A lot of constitutional scholars talk about Article 3 as, quote, magnificent in its brevity. And what they really mean is that it's very short. It's not much longer than a paragraph. And why is that? When other parts of the Constitution are so very long, when the parts establishing Congress or establishing the executive branch are really, really long, why is the court system so short? And the reason for that is one of the few pieces that we brought over kind of wholesale almost from Great Britain. So we adopted the court system almost entirely from Great Britain, and we tweaked a couple of little things, right? So there are parts of the Constitution that say, we can't use bills of attainder to find somebody guilty of a crime without trying them. People are entitled to habeas corpus, so they can't be held indefinitely without seeing the inside of a courtroom to adjudicate their claims. The warrant clause in the Bill of Rights, right? All of those are things that sort of amend or slightly change the court system, but operationally, the court system functions in the United States very, very similarly to what the colonists were used to when they came over from Great Britain to begin with. Article 3 doesn't establish judicial review, right? It does not create the ability for the Supreme Court of the United States to adjudicate claims that either Congress or the executive branch have overstepped their boundaries or are violating the Constitution. So where does the court get that power? Oh, shoot. We'll have to skip around a little bit. So the court gets that power from a Supreme Court case in 1803 called Marbury v. Madison. It's funny because this is sort of one of the foundational, keystone cases of our entire justice system. It's in the entire way that the courts sort of function. But the facts of it aren't really that important. The important part of it is that it establishes the Supreme Court's power to review congressional and executive actions for constitutionality. And so that's the concept that we call judicial review. So that's where that comes from. But let's bop back up and talk about some jurisdictional questions. So there are lots of types of jurisdiction. And the question of jurisdiction is really a question of, which court does what. And so so you have original jurisdiction, right? Original jurisdiction is the authority of a court to hear and decide both questions of law and questions of fact, right? And in a jury trial, your jury is the finder of fact, but your judge is the finder of law, right? And so what does it mean to be the finder of law or to decide questions of law? How are those distinct from questions of fact? Well, so questions of law are questions of, did the government violate the rights of this defendant, right? So was the search conducted lawfully? Was the defendant interrogated without being given access to their attorney? Does the defendant have representation now, right? Those are all questions of law that are decided by a judge. And then the finder of fact sort of gets all of the evidence that is admissible under the law and then makes a factual determination based on that. So determines, did the defendant commit this crime or not, based on the evidence that is admissible legally in court. So that's original jurisdiction. They are the finders of law and the finders of fact. So we would maybe call courts of original jurisdiction in the criminal justice system the trial courts. And you can contrast that with courts of appellate jurisdiction. And appellate jurisdiction is the power of a court to review a case for errors of law. And so when a defendant appeals to an appeals court, right, and we'll talk about the appeals courts in a minute, the defendant is not appealing on the grounds of, I didn't do it, right? They are appealing on the grounds that something, a piece of evidence was admitted erroneously, that the trial court judge erred, made a mistake in allowing a particular type of evidence to be considered, or maybe erred in sentencing, made a mistake and sentenced the defendant more harshly than they ought to have for any number of potential legal reasons, right? But appellate jurisdiction under the common law, which is the type of law we brought over from Great Britain, only allows for review for errors of law, not for errors of fact. There are some jurisdictions that have amended that by statute and have either allowed appellate courts to consider errors of fact under some very limited circumstances, or created separate appeals courts. Some jurisdictions refer to them as like actual innocence courts. And this is in response to sort of the wave of exonerations that we've seen in the wake of DNA evidence being admissible. And so there are a lot of folks who were tried before DNA evidence was particularly good who are saying like, no, really, I'm innocent. I did not commit this crime. And so if new evidence comes to light, it can be adjudicated statutorily either at the appellate level, the same way an error of law could be, or through a similar but distinct type of court. But under the common law, appellate jurisdiction was only for errors of law. So, yeah. General jurisdiction refers to the power of a court to hear any type of case. So when you would think of your criminal trial court, right? A defendant who's been accused of just about any crime can appear in a trial court of general jurisdiction. And you can contrast that with trial courts of special jurisdiction. So special jurisdiction courts are, that might include drug courts, because for a variety of reasons. One, for the ability to divert defendants. It might also be because to authenticate drugs, to show that the defendant actually had drugs and not baby powder or oregano or, you know, whatever. You have to have a chemist on call, and it's really expensive to continually be having a chemist sort of like pop over from the state lab to your court. And so generally drug dockets are courts of special jurisdiction that are set up on particular days. In some jurisdictions, family violence courts or domestic violence courts are courts of special jurisdiction, and that's because the judge and the prosecutor are specially trained in the particular issues that victims of domestic violence face, and generally the victim is entitled to a victim's advocate who can help them identify services that they're entitled to and also help them navigate parts of the civil justice system that they might need access to, like a restraining order. So in some jurisdictions, those are courts of special jurisdiction. And then another sort of version of a court of special jurisdiction is juvenile court, right? Where there's a lot of sort of different rules and it's very specifically restricted to minors, to people who are under the age of 18 when they committed, in the juvenile system, we would call it their active delinquency, not a crime. And then finally, you have personal jurisdiction. And this is much more important in civil law, but it's conceptually valuable here too. And this is the court's authority over the parties to a particular case. Generally, we would say the court has both personal and maybe subject matter jurisdiction over any defendant who is alleged to have committed a crime within the physical boundaries, within the physical jurisdiction of the court. So right now I'm sitting in Anne Arundel County. If somebody broke into my house right now, they would be tried in Anne Arundel County, and that court would have jurisdiction over them because that's the location where the crime was committed. Even if they were from Virginia or New York or New Jersey, the court here would have jurisdiction because it's where the crime occurred. That is a far more complicated question in civil law, but good news, we don't really have to worry about that. So, the federal court system is actually fairly easy to explain, which is why we'll talk about it first. State courts are a little bit more sort of convoluted in some instances, but at the very bottom of the federal court structure, you have your trial courts. In the federal system, those are called district courts, and there are 94 of them. The next level up, so if you're unhappy with your result at trial, you can appeal, if you're the defendant, after the result is in, you can appeal to one of the circuit courts. Why can't you appeal, why can't the government appeal a case? Because if the defendant is found not guilty, retrying them would put the defendant in double jeopardy, right? Which is banned in the Constitution. We don't get to just keep trying people over and over again until we find them guilty. That's against the rules. So the defendant can voluntarily put themselves back in double jeopardy, because if they've been found guilty, what's the kind of worst thing that can happen other than they're found guilty again? Only the defendant can appeal after a final decision is entered by the trial court. There are limited opportunities if things are like really bad and we kind of need to hit the button on the prosecution side. Those are called inter alia appeals, and they're very rare. So they exist. It's very rare. You're unlikely to see them. But anyway, your appeal would go from the federal district court to one of the federal circuit courts. And there are 11 numbered circuit courts, and then the DC Circuit Court, which does not have a number. It only covers the District of Columbia. And the DC Circuit Court really gained in prestige when, in the mid-2000s, the Supreme Court sent all appeals from the Guantanamo Bay cases to the DC Circuit Court when they determined that defendants had the right to appeal from the findings of the cases that they were being tried in at Guantanamo. Those appeals go to the DC Circuit, and so that became a very sort of prestigious court appointment. And you do see a lot of justices on the US Supreme Court coming from the DC Circuit recently. And then finally, of course, an appeal from the circuit court would go to the United States Supreme Court. And that's the Supreme Court of, we've abbreviated that as SCOTUS kind of, I think, throughout the slideshow. So we'll talk about how those appeals work in a second. I want to switch to talking about the state courts only because the appeals from the circuit courts to the U.S. Supreme Court work similarly to appeals that work to the Supreme Court through the state court system. So at the very bottom level of the state court system, you have state trial courts, which are very similar to federal district trial courts. You might also see magistrate courts or like juvenile courts or other courts of special jurisdiction at this level. So they're not all general trial courts. But like, even if you are, like, let's say you get a parking ticket and instead of going to a trial court, you go to a hearing in front of a magistrate, right? Which is far less formal. You're not necessarily entitled to representation if you can't afford it, and most people don't bother. But you would not appeal. I didn't put it below the state trial courts because you would not appeal your finding from a magistrate's court into a trial court. I don't know why you would really appeal one at all, but here we are. And so from there, from the state trial court level, if, again, the defendant is unhappy with the outcome at the end of the trial, so they've been found guilty, probably. That's why you would be unhappy with the outcome if you're the defendant. Then you would appeal to the state intermediate appellate court. A lot of states, maybe most states, would call this like the Maryland Circuit Court or the Maryland Court of Appeals. But given that states are allowed to call their courts kind of whatever they want, I've just noted that the general term for them is the intermediate appellate court. Many states have the first appeal, so the appeal to this intermediate appellate court, as what they call an appeal of right, which means that you are entitled to representation by the state public defender's office or the county public defender's office, depending on how your state does it, at that first appeal. So you are still entitled for the state to pay for your lawyer at that first appeal. Beyond that, you might have to either pay for your own representation or get like a nonprofit to provide representation for you. And there are a lot of those, but it's kind of a little bit more of a complexity. The next court on this list is the State Court of Last Resort. It is often called the state Supreme Court, so the Maryland Supreme Court, the Pennsylvania Supreme Court, but it's not always called that. And so different states have different names for it, and so I've just sort of noted that it is the State Court of Last Resort. From the State Court of Last Resort, can you appeal to the U.S. Supreme Court, to the SCOTUS? Yes, but only if the case implicates a substantial federal question. So in criminal justice matters, it almost always will, right? Because it's generally going to be about the 4th, 5th, 6th, or 8th Amendment to the Constitution, which have been incorporated as applying to states via the 14th Amendment. So basically back in the 60s, the Supreme Court says whether defendants receive due process in criminal justice matters is our business. And we are allowed to determine whether that happened or not and judge that against constitutionality based on the 14th Amendment. And so generally, criminal justice matters could at least theoretically make it to the U.S. Supreme Court. But there are a lot of things that might not, right? So lots of things like state tax questions, state like probate of wills or state real estate transactions or divorces or custody issues are all things that might not have a substantial federal question component. And so, you know, the State Court of Last Resort may be the court of last resort. So the writ of certiorari. This is the application. So if you want to appeal your case to the U.S. Supreme Court, you file for a writ of certiorari, and then the court has the power to grant that writ of certiorari. And we abbreviate that by just saying they have the power to grant cert. Many, if not all, state Supreme Courts or state courts of last resort have similar processes to determining whether or not they want to hear cases. right? So what a writ of certiorari really does is it's an order to the court immediately below it that the defendant has been in, ordering that court to forward all the records, so all the appeals records, all the trial records, all of the evidence, like everything, to the Supreme Court for reconsideration. Usually, granting the writ is discretionary, and 4 justices have to agree. There are some exceptions to that when the court is sort of forced to act. Largely, that's when there's like a conflict of laws between state and federal like laws and constitutions. And so federalism and the supremacy clause are kind of implicated. Those are really rare. There's another instance that is technically discretionary, but generally the court jumps into this one like their hair's on fire. And that is when federal law is interpreted differently across appellate circuits. Or across different parts of the United States, right? So like imagine a hypothetical where the Ninth Circuit Court of Appeals says the death penalty violates the 8th Amendment, right? And so all of a sudden the 8th Amendment means one thing in the Ninth Circuit and it means something different in the other 10 circuits, right? That's not good. We don't want that, right? Laws have to mean the same thing. If they apply equally across the country, they have to say the same thing and mean the same thing. And the Constitution is the same way. Differing constitutional interpretations across the country when we're supposed to be governed by one constitution that means one thing is not great. And so generally there, the Supreme Court will very, very quickly get involved. Yeah. So there are some other questions about, you know, kind of how the courts work. And these are called issues of justiciability. And there are 4 kind of big ones, right, that come up a lot in decisions, especially the kind of the first 3. And the 4th is really just like why the court very rarely is really bound to what's in front of it. And so it never gets really just talked about that much in cases because there already is a case in front of it. But mootness asks, if the underlying condition that triggered the claim expired, or if something else has happened that has made the outcome of the case irrelevant, right? So do we need to proceed with this 6th Amendment claim that the defendant was denied counsel if the defendant drops dead in prison? Probably not. Right? Because it is moot, right? Whether this defendant received appropriate representation. Another example of that, and an instance where the court actually said, under most circumstances, we would decide that this case was moot, but we're not in this case, is in Roe v. Wade. Jane Roe gave birth to the baby before the case arrived at the US Supreme Court. And so the state said, the case is moot, like she doesn't need an abortion anymore. And the court said, true, but the thing about being pregnant is that after 9 months, you like generally almost always stop being pregnant because you have a baby. And so if we were to constantly say this was moot, we'd never be able to decide an abortion case on its merits because it takes so long to get from the trial courts to the US Supreme Court. So they sort of overrode the mootness claim. So the next question of justiciability is ripeness. And this is a question of, has the law in question actually been applied to someone's detriment? Is there a real harm? Has the government used the law to do a thing yet, right? And has there been sort of an impact to that thing? And if not, then the decision is not yet, or the law is not yet ripe for review. The question of standing says that only parties that are affected by the law can sue. So in like the recent immigration cases, that ended up being decided in like Hawaii v. Trump, standing was a big question, right? And the question is, why do these particular states have standing? They're not immigrants themselves, right? And the question was a question of tourism and travel and lots of other things that ultimately implicated standing. Some other potential plaintiffs in those cases were like universities, like state universities, who rely on out-of-country students coming in and whose students would be barred from either coming in or then leaving and coming back. So the party has to be affected by the law. They can't just be sort of like a sympathetic bystander. And then the final question is, it has to be a case or controversy. So the Supreme Court can't just be like, hey, just so everybody knows, here's how we feel about this particular issue, right? They have to have a case in front of them that they can rule on, right? A lot of times that's why Supreme Court justices in their Senate confirmation hearings don't like to sort of like predict what they would do, because it seems to sort of violate this bar against giving an advisory opinion. Obviously it doesn't for the whole court, but if you can kind of like get a plurality of those together, you would know. And so, you know, the court wants to limit their scope to cases that are actually in front of them, so as not to have a chilling effect on the other two branches, I guess. Another important concept for you all is the concept of stare decisis. This is a Latin term. It means the decision is fixed or the decision is stable. And what it generally means is that once the Supreme Court has decided a legal precedent, it is binding both forward in time and down the legal hierarchy. So on the circuit courts that are below it, and on the district trial courts that are below it, and then on the state side, on if it is, you know, something that implicates the states, it's binding on state courts of last resort and state appellate courts and state trial courts as well, until that decision is overturned by the Supreme Court, right? Or until the court overrules itself. And that is true for other courts too. So if the Maryland Supreme Court issues an opinion, that is binding on courts that are below it in its hierarchy, until the Maryland Supreme Court either overrules itself or is overruled by the US Supreme Court, so a court that is above it in the hierarchy on that question. What is the difference between overturning or overruling, which are kind of used interchangeably in legal literature, versus a distinguishment, right? And this is going to be relevant because if the affirmative uses the language overrule or overturn in the plan text, it's possible that the negative could read a counterplan that says instead of overruling the decision, we should distinguish the decision. So an overturn or an overrule eliminates the precedent forever. It says that precedent is no longer good precedent. We are replacing it with a different precedent, right? And so like an example of that would be like Plessy v. Ferguson is no longer good law. The court overturned it with later decisions, right? Distinguish takes a case, like an older case where the court wants to make a different decision and limits that case to its facts. So it says the precedent, like the precedential value of that old case is limited, and it's largely replaced by this newer case that's maybe more on point. But in those very, very particular circumstances, were those almost exact circumstances to arise again, it is possible that that decision could go forward and have precedential value. Yeah, a good example of that might be Korematsu. Until very, very recently, Chief Justice Roberts sort of like ad hoc overruled it in like a dicta and was like, this means that we would never apply Korematsu. But up until that point, there had been cases that had, you know, eliminated precedential value of Korematsu, but the decision itself was still sort of on the books and standing. And so it's possible that it could have been used as justification for internment during very similar circumstances, like when we thought the homeland might be under attack, those kinds of things. Yeah, so that's kind of the difference. Distinguish leaves some precedential value in place and preserves some degree of stare decisis, and just says this other case is so different and that we're establishing sort of a different precedent going forward. We can briefly talk about some of the disad stories I think you might hear if you read Court Staff. So court capital, which is sometimes called court's politics, argues that the court attempts to balance its rulings to look like a neutral or non-political actor. So if the plan is a liberal decision, right, the court will make another high-profile conservative decision to balance it. And then you would generally read evidence as to like sort of what case is most likely to be up in the air and like a 5-4 where a justice would swing in one direction, which is certainly the best version of that story, right? You would identify a particular justice as a swing vote who is committed to maintaining court capital. When I was debating, that was Justice Kennedy. Today, that is probably Justice Roberts. Who is very, very invested in sort of making the court look like a neutral body or a non-political actor. And so tends to balance liberal decisions with conservative ones. And then you would just have to sort of read evidence that like a particular judge was the key swing vote on that case that could go the other way, and then an impact to it. Court legitimacy is a similar story, but it's a little bit different. This is about the sort of stability of the court, or the sort of like stare decisis of like individual decisions. And so if the decision is sort of like an overrule of a fairly long-standing or fairly large precedent, you know, this might be your story. And it argues that the court acts to preserve stare decisis to reinforce its own legitimacy as sort of a co-equal branch of government, which is sort of important for its ability to check the other branches, right? And if you think about it, right, really the court only has its sort of legitimacy. They only have their good name, right? The president controls the sort of federal police, right? So he's in charge of the DOJ, which controls the FBI, federal marshals, the DEA. All of those are things that are under the control of the president. The president also has the military, right? So like the president has some like coercive power. Congress has money. They can fund things or not fund things as they want, right? Which is an enforcement power. The courts have, I don't know, fancy robes, gavels, right? All they really have is their sort of willingness to say, we defend the Constitution. And it's possible, and in fact has happened in the past, that the other branches have said, we don't really care, right? We're not invested that much in the Constitution as a legitimate document. We don't really care what you have to say. We are interested in doing what we want to do for our own political reasons. And so they ignore the courts. And the court, right, a lot of people talk about the court as kind of like the last bulwark or like wall against authoritarianism, right? And the courts have really been traditionally thought of that way since, you know, before the revolution, really dating back to like the Magna Carta, right, in Great Britain, like the 12th century. We have really thought about the courts as one of the last few things that can protect people from sort of arbitrary enforcement of laws by executive or legislative branches that just like have a vendetta, right? So the lack of court legitimacy might cause the breakdown of the rule of law. It might cause the breakdown of democratic norms. I think this sort of seems more true to me than a court's politics or like court capital DA, because I think the cards on this question are probably fairly decent. I would bet the problem here is going to be kind of at the internal link level, that there's going to be a fairly high threshold for like a break, right? Like what causes, like, what about this decision causes democratic breakdown, right? And so I think your cards are going to have to be like fairly good on this question, that like we're at the tipping point now, right? Where the president is very, very close to just like blowing off the court and doing whatever he wants. Are those cards there? Probably. So I think that might be a pretty good disad against court side. Question I always get, do court decisions link to politics DAs? Probably yes, come on, judge. I feel like my gut instinct is yes, you might need to read evidence on these questions, right? So one, the courts are often perceived by the public as political actors who have an agenda that matches either a liberal agenda or conservative agenda. So if the court does something that is unpopular with the public, one party or another gets blamed. Or if the court does something that is popular with the public, one party or the other gets credit, right? Particular to this topic, the government is usually a party to criminal cases, right? Especially federal criminal cases. The Solicitor General argues those cases on appeal before the Supreme Court, which is an executive office under the president. And so those could be perceived as a win or a loss for the president. And even ones that happen at the state court level, right, could be perceived as wins or losses for, you know, whatever party is in control of like the governorship or whatever. For the elections DA, the control of courts by liberal or conservative jurists is often used as an argument for voting for one party or another, and that's like empirically proven. So the backlash to Miranda v. Arizona was so great that it swept Nixon into office. Based on promises to overturn Miranda v. Arizona. And other sort of like left-leaning sort of don't destroy state defendants just for the sake of it kind of cases that had come out in the 60s. I have also some random definitions at the end. So an amicus curiae or an amicus brief, a lot of times you'll hear about these sort of referred to in cards. An amicus curiae is Latin for friend of the court. So an amicus brief is filed by an amicus curiae, and an amicus curiae is a person who's not a party to the lawsuit, right? They're not part of the case. They're not the defendant. They're not the state. They're not the plaintiff. They are just interested in the outcome. Right? So they're an interested third party who might make either legal or public policy arguments, or often both, for why the court should decide a case in a particular way. In a lot of criminal justice cases, you'll see the ACLU or the Southern Poverty Law Center or other similar, the Innocence Project, right, as amicus, amici in the case. And they will file briefs with the court, just like the briefs that the parties themselves file for review by the justices before they make a decision. Rule of law, which I've referred to a couple times, is just a principle under which all persons, institutions, and entities are accountable to laws that are publicly promulgated, equally enforced, independently adjudicated, and consistent with international human rights principles. And so what that really means is the idea that nobody is above the law, that the president still has to abide by the laws of the United States, that members of Congress do, that judges themselves have to abide by those laws, that nobody sort of gets to say, like, I make the laws, I am the law, I don't have to, like, abide by the law. Habeas corpus, which you'll see referred to in a lot of criminal cases, is a Latin term that means bring forth the body. And it literally orders the government to do that. It's a court order mandating that the government produce someone that is being detained in court, so the government can justify that detention or explain to that person why they're being detained. The last thing I want to talk about, and I did not make a slide for it, are categories of judicial scrutiny or judicial review. And these are really important, and I think a couple of the AFs that we're reading, even in the starter set, make reference to them. But these are the sort of bases for making a decision, the sort of framework that judges use when they're evaluating claims against the government. And there are three types of scrutiny, or three sort of levels of scrutiny. The first and most basic is rational basis review. And this just says that the government has to have a rational basis, hence the name, for discriminating against a particular class of people, for sort of having a law that discriminates against a particular class or type of people. And this is for classes who are unprotected, so that don't have any special constitutional protections. So like age is one of them, or like maybe socioeconomic status is another one. Yeah. The second category, intermediate scrutiny, generally applies to gender policies that are discriminatory on the basis of gender, either sort of de jure or de facto, right? So if the policy doesn't necessarily discriminate against you based on your gender, but sort of has the effect of discriminating against you based on your gender. And then the court has very recently said that included in those cases are also gender identity and sexual preference, because they functionally, policies that discriminate about those things are also functionally about sex discrimination, right? Because they tolerate in one gender what they would oppose in another. So a great example of a law that kind of, does that would be, let's say that a jurisdiction says that to be a firefighter, you have to be able to lift 300 pounds, put it over your shoulders, and walk 20 yards. And very few people can do that to begin with. Like, that is a high standard. But far fewer women can do that than men, because women have sort of much lesser upper body strength. So the ability to lift somebody and then carry them would be very difficult for the vast, vast majority of women. And so the policy de facto discriminates against women, but there is a good enough reason, a compelling reason that the government has to engage in that type of discrimination. And the reason is we want our firefighters to be able to pick up even fairly large people and escape flames with them, right? And so that would probably pass intermediate scrutiny. And intermediate scrutiny recognizes that gender is a protected class, but that there are meaningful differences between people sort of physically and physiologically based on their sort of like gender, their physical characteristics. And so you generally do see these as de facto discrimination claims, not sort of like we intended to limit women out of this profession, which it would be difficult, I think, to convince the court that there was a compelling reason to do that. The final category is strict scrutiny. And strict scrutiny is applied to cases where the defendant is alleging discrimination by the government on the basis of race, ethnicity, national origin, or religion. And it is very, very unlikely that the government is going to pass muster, that whatever the policy is going to pass muster. You can kind of think of this as shifting burdens of proof, right? So in rational basis review, the plaintiff, right, the not government party really has the burden of proving that the government has done something wrong. And that burden sort of shifts a little bit, but still exists in intermediate scrutiny, right? So the plaintiff in rational basis has to prove that the government engaged in something that was illegal. And then the plaintiff has to sort of prove that de facto case, and then the government just has to respond with, we have a compelling reason. And by the time you get to strict scrutiny, the burden of proof has shifted to the government to prove that what they did not have discriminatory intent, or if it did, it was so justified that it was necessary. So interestingly, the first case to apply strict scrutiny review was Korematsu. And it's one of the only cases, it may be the only case where the government has then passed the strict scrutiny test. But generally, if the court is applying strict scrutiny, the government's going to lose. And generally, if the court is applying rational basis review, the government's going to win. And then intermediate, kind of toss-up. So those are your categories of judicial review. And I didn't put those in the slideshow for the purposes of this lecture, because I just left them out, but I will amend the slideshow. And so when you get a copy of the slideshow, it will have those at the end. And I hope you enjoyed this, and I hope you learned some stuff, and I hope you have lots and lots of fun debates about the courts this year. So with that,